that you can be revived, but they are putting you on gadgets. And excuse some of them are, I know, doctors, including Dr. Bobby. We find there is an abuse of this process also. Many places people have gone on with their ventilators, notwithstanding that there was nothing inside the body. So to look at all this, we found the Supreme Court took upon itself in a common cause petition to lay down law as to what can be a living will. And this is nothing new. It has a history behind it. But instead of taking towards the history, because that's not really the purpose, in 2018, they laid down the principles under which a person would be able to make a living will. It provided who can do it. It provided who will attest it. It provided whose custody it would be, etc., etc., etc. But over a period of time, they saw that the formalities were too complicated and it was not possible to implement it within a given reasonable period. So in 2023, the Supreme Court once again took upon itself and changed those guidelines, which are today in force. So the first is that what is called Advanced Medical Directive serves a fruitful and felicitates a right which is part of the Constitution, right to life, right to dignity. These said directives, in the words of the Supreme Court, will dispel many doubts in the relevant time of need during the course of treatment of the patient. That apart, in their words, it will strengthen the mind of the treating doctors as they will be in a position to ensure, after being satisfied, that they are acting in a lawful manner. We may hasten to add that Advanced Medical Directive cannot operate in abstraction. There has to be safeguards, they need to be spelled out, and then they enumerate the same. So the Supreme Court was cautious that it is necessary. Supreme Court said in its opening words that yes, it's the need of the hour. And it will not only help the patient or any one of us who may be in that state, but it will also help the doctors to ensure that after being satisfied that they are happening in a lawful manner. Beautiful. But this today, because if you see Consumer Forum jurisdiction today, and if statistics are correct, most disputes are today medical disputes going to that court, that tribunal. Either they are people who have not been able to get their flats, or people who are been maltreated, not treated well, or the doctor has not paid the attention, therefore there's a medical deficiency, they are asking for their compensation. So in order to safeguard the doctor also, this mechanism was provided by the Supreme Court. So not only is this question is first, that when you execute this document, any one of us must be of sound deposing mind. I must be capable to understand what am I writing. मुझे समझ लगनी चाहिए मैं लिख क्या रहा हूं. मुझे समझना चाहिए कि मैं जो शब्द लिख रहा हूं उसमें what is the consequence of it and when it can occur. आपने अभी पढ़ा, आपके फ्रेम में लिखा हुआ था living will, when and where. You can be anywhere. You can execute it, provided you understand, you are capacitated to understand what are you writing. It's not that you're already suffering from some disease which doesn't allow you to take your own decisions. Let me give you a very small example to come back to it. Supposing a child is right from his childhood or her childhood not able to look after her interests. So a guardian is appointed. Even otherwise, you will find many times this has happened when both parents have died and there's nobody else. Then a guardian is appointed of that child. Similarly, a person nominates his guardian. he is entitled to under this living will. He will say either my wife, in the event of my wife not being available, my son, and supposing both are not available, then I hereby nominate Mr. So-and-so and Miss So-and-so to be my guardian. That guardian would be able to bring this to the notice that I have expressed my desire that when should this stop treating me because I've reached that stage where there's no chance of my coming back. Now, coming back is not subject to a whim of the doctor. When he comes to know about it, he then refers the matter, it goes to a primary board constituted of doctors. The primary board examines everything and then clears it or says no, he's still in a position to come back. And that board's check is second board. When it goes to the second board, then only the decision gets taken. And then you also bring a check now in law that the judicial magistrate of that area is then notified, who then allows, after examining everything, that yes, this treatment should be stopped. Because the person gets to this earth or goes away from this earth only with one desire, one mandate, and that mandate is of God. If that mandate nobody else can take. So you will see, if I was to kill somebody, then I'm charged with murder. I would make to suffocate somebody, then I'm also charged with murder. Therefore, otherwise there will be complications that are coming. Therefore, the necessity was for this living will. So once we do that, then the law says, in such an eventuality, the doctor will be within his jurisdiction to take a call that he should now stop any medication to you, all gadgets to you, all, even if you are on oxygen or anything, you may stop, ventilators will stop, everything should stop. And that's what it should, that where this document comes important. सबसे पहला इसका असूल है कि ये राइटिंग में होना चाहिए. I am not saying your own handwriting. You can also be a computer savvy, so you can type it. You can also ask somebody else to write it for you. But as long as you can be satisfied that जो लिखा हुआ है वो आपको समझ में आ रहा है, वो आप समझ सकते हैं. आपको एक मिसाल दे दूं कि अगर जब कोर्ट में एफिडेविट फाइल करते हैं तो इंग्लिश में फाइल करते हैं, पर हम लास्ट में जिसको अंग्रेजी नहीं आती उसमें लिखते हैं हम, the oath commissioner certifies it कि जी इस आदमी को एफिडेविट में क्या लिखा है पढ़ के सुना के समझाया गया और उसने अफर्म किया कि हाँ मैं ये एफिडेविट लिख रहा हूँ उसकी लैंग्वेज में, तब वो अफर्म करता है उसको. सो आपको भी यही पहले सोचना पड़ेगा कि आप या तो खुद लिख रहे हैं, आप खुद टाइप कर रहे हैं डिफरेंट क्वेश्चन, बट इवन इफ समबडी एल्स इज डूइंग फॉर यू, then you must be able to understand what is written there too. Therefore, it must be an informed consent by you, in the sense that you have understood इसकी नीड आ सकती है कभी लाइफ में, स्पेशली फॉर द एल्डर्स ऑफ अस. इसको क्यों जरूरी पड़ेगा हमारे को करना, वी मस्ट अंडरस्टैंड द नीड फॉर इट. सो वी मस्ट अंडरस्टैंड, कोई कंपल्शन नहीं है इसमें. इट्स नॉट नेसेसरी द लॉ सेज आप करेंगे करेंगे. It is always voluntary for you to do it, provided it is informed consent given without any undue influence or coercion. It's not that your brother or your mother or your wife or your children are putting pressure on you that, Amajit, please sign it. Not that. You must voluntarily sign. A. It must be in writing. B. 3. It must be before 2 witnesses. अगर आप नॉर्मल विल भी देखेंगे, नॉर्मल विल में भी लॉ की रिक्वायरमेंट है कि वो विल 2 टेस्टिंग विटनेसेस से साइन होनी चाहिए. कानून में 2 ही डॉक्यूमेंट है, एक गिफ्ट डीड और एक विल, जहां पे 2 टेस्टिंग विटनेसेस की जरूरत है. अदरवाइज यू कैन डू इट अवे विद इट विदाउट इट, इवन इन अ सेल डीड, नॉट नेसेसरी फॉर यू टू डू सो. बट हैविंग गिवन दिस स्पेसिफिक फॉर्मेट इन द गाइडलाइंस गिवन बाय द सुप्रीम कोर्ट, आपको समझना पड़ेगा क्या लिखा है आपने, आपको राइटिंग में होना चाहिए उसको, और जब आप दस्तखत एग्जीक्यूट कर रहे हैं उसको, उस वक्त 2 अटेस्टिंग विटनेस आपके सामने होने चाहिए, who also append their signatures certifying that you have executed it in their presence. Then comes the next stage. Either नोटरी पब्लिक को आप उसी वक्त अपने घर बुला लेंगे या जहां भी एग्जीक्यूट कर रहे हैं, या आप उस डॉक्यूमेंट को नोटरी पब्लिक के पास ले जाएंगे और नोटरी पब्लिक उसको अटेस्ट करेंगे और पूरी अपना सर्टिफिकेट देंगे that this has been voluntarily executed by you and you affirm that contents of the same you have understood and you have executed the same of your free will voluntarily. This is stage 1, because that document must clearly understand or must clearly depict, in other words, कि कौन से डिसीजन किस टाइम पर ये कर सकते हो आप. You must specify that in your document. You must indicate the decision relating to circumstances in which withholding or withdrawal of medical treatment must be resorted to. That must be stated in this will. कि किस स्टेज पर जाके आपको बंद कर देना चाहिए उनको देखना. So you have to bring this clarity, and you must bring absolutely in clear specific terms that this decision, if I am not able to take it, I am not in a state to do so, then who will take it? Could be your wife, could be your husband, and vice versa, could be your son, could be your daughter. And if none of them can you think would be available or can be available, then you can yourself, as I said earlier, appoint a guardian who can be your relation, who can be a very close friend also, who can be your guardian, who will have the right to act as a guardian and then listen. And the best part of this is that the document once executed, यानी कि absolute हो गया हमेशा के लिए. You can revoke it anytime if you want. You think no, ये मेरे गलती से हो गया, या आपको बाद में समझ में आई बात, तो आप उसको रिवोक कर सकते हैं. आप उसको रिवोक करके डॉक्यूमेंट बना के कि ये मैंने एग्जीक्यूट किया था, इसको मैं रिवोक कर रहा हूँ. एंड देन यू शुड मेंशन कि मैंने कौन सी डेट को ये एग्जीक्यूट किया था और ये मैं कौन सी डेट को रिवोक कर रहा हूँ. So that there is clarity, nobody can misuse it tomorrow. Then consequences के क्या हैं वो भी आपको समझ लेने चाहिए. One must understand what are the consequences. The consequences is only one, that at a stage जो आप specific करेंगे उस document में कि किस stage पर medical facility आपसे withdraw कर ली जाए, at that stage you must appreciate in your document itself कि कौन सी stage पर आप उसको withdraw करेंगे. Not that simply you have gone to the hospital and you say, no, I don't want medical treatment. That's not the issue at all. You will reach a stage where the doctors tell you कि आपके chances वापस आने के बहुत कम है या है ही नहीं. One of the two things. Many times doctors give this opinion. कई बारी मरीज इस हालत में होता है, आके सबको कहते हैं आपको जिसको बुलाना है बुला लीजिए प्लीज, तबीयत ऐसी खराब हो गई. So this is very necessary for us to look at it. अब जब आप उसका गार्डियन अपॉइंट कर देंगे, या आपके अपना बच्चा है या आपकी बीवी है या हस्बैंड, आइदर केस, then he will be the person, if you are incapable of taking a decision on the hospital bed, to take a decision for you. Yes, the stage has reached where this medical facility or medical thing must stop. And that once you have one advance directive, you can do it, and that person will then move to the doctor. There is official record for it, which is the municipal corporation insofar as Delhi is concerned. Similarly, अगर village में हो तो पंचायत हो जाएगी, और जहाँ पे भी आप हैं उसकी municipality हो जाएगी. So a record of that document has to go there, so that if somebody wants to verify it, it can be verified that you had actually executed the same, in case कोई dispute खड़ा हो जाए. Now the question would be, जब आपने इसको एग्जीक्यूट कर लिया, पहले इसके 2018 में था कि ये काउंटर साइन होना चाहिए जुडिशियल मैजिस्ट्रेट से भी, and we found it was very difficult to do so because the judicial magistrate may not know me personally. He will say, yes, you have executed, why should I certify it? So इसको 2018 में जब हमने देखा बहुत दिक्कत आ रही है हमको, तो अब 2020 में उसको चेंज कर दिया हमने कि ये कह के कि आप एक नोटरी पब्लिक से टेस्ट करा लीजिए, और अगर आप किसी गेजेटेड ऑफिसर गवर्नमेंट के जानते हैं उससे टेस्ट करा। So instead of judicial magistrate now, the substitute is a notary public or a judicial officer or a gazetted officer. So once you do that, then पहले होता था विटनेसेस भी पेश होते थे जुडिशियल ऑफिसर के सामने, मैजिस्ट्रेट के सामने, और वो कहते थे हाँ जी उन्होंने मेरे सामने एग्जीक्यूट किया। और मेनी टाइम्स वी फाउंड एक बंदा पहले दिल्ली में था, वो शिफ्ट हो गया, इट वाज बिकमिंग डिफिकल्ट टू ब्रिंग हिम बिफोर द मैजिस्ट्रेट। सो वी शिफ्टेड दैट टू से witnesses and the gazetted officer shall record their satisfaction together now. So notary public, as I said earlier, you can even call home. You will have to only pay his charges and he'll be at home to attest it, not that you have to go. अगर आप किसी gazetted officer को जानते हैं, I'm sure he can oblige you by coming home or you can go to his office. So it's not that difficult. So जो दो attesting witnesses हैं उनके साथ आप जाके notary public से attest करा लीजिए और उनसे attest करा लीजिए gazetted officer. That choice is with you. Because the purpose is this, that the notary public is bound to ask you, have you understood the contents? क्या आपने लिखा क्या है इसमें, क्या एक्सप्रेस करना चाह रहे हैं? That's all. And consequences उसके आपको समझा देगा before he puts his signature. अब आगे होता था कि जुडिशियल मजिस्ट्रेट जिसके सामने हम टेस्ट करते थे वो उसकी कॉपी रखता था। हमने देखा एज रिकॉर्ड विल से कि कोर्ट के रिकॉर्ड या मजिस्ट्रेट के रिकॉर्ड बीट आउट हो जाते थे। उसको कोई तरह डिजिटल सिचुएशन नहीं थी, आज भी नहीं है गवर्नमेंट में इतनी कि हर चीज रिकॉर्ड में चली जाए। इट रिमाइंड्स मी ऑफ वेरी ओल्ड पोजीशन व्हेन वी फाउंड के सर्टेन रजिस्टर्स ऑफ योर सेल डीड्स एंड मॉर्गेज डीड्स वर नॉट गोइंग इनटू द रजिस्टर्स। नाउ ऑफ कोर्स इट्स डिजिटल, नाउ इट इज यू हैव टू गो देयर, इट गोज ऑन ए कंप्यूटर। But till such time it was not there, it is not still with magistrates, that position that they could do it. Therefore, this provision also was deleted in 2023. Now you don't have to do that, that the magistrate will keep a copy of it. Then the judicial magistrate or the executor is now bound to inform and hand over a copy of the advance directive to the person named in the paragraph which I said earlier, as well as to the family of the physician. So the person जिसको आपने नेम किया है कि वो मेरे इनकैपेसिटी हो जाने के बाद कौन डिसीजन ले सकता है, वो उसकी कॉपी लेके उस फिजिशियन के पास जाएगा, उस डॉक्टर के पास जाएगा जिसके पास आपकी पैरवी हो रही है, to tell him that you had executed this living will and consequently you should now look at it from this point of view. And then I told you two situations will come. If the doctor is satisfied, he will send you to the primary board, then the primary board will the secondary board, then the magistrate comes in, and then that's where the decision is taken. Then one of the things that you can hand over to is that you can put it in your own health records. आज तो क्लाउड में सब कुछ हो जाता है, आपके अपने सर्वर में हो जाता है। सो आप उसमें भी अपना ये रिकॉर्ड अपलोड कर सकते हैं, so that if somebody wants to retrieve it from there, it can be retrieved at any time. So you have now, instead of going to judicial magistrate's record, you have a record of the municipal corporation, you have own record of your own medical situation where this gets uploaded. So that if somebody takes out your medical record, this document will also come forming part of it. Now question arises, when and by whom can it be given effect to? I have already said in the event of the executor, terminally ill. Now, terminally ill will be decision of the doctor. He will tell you, yeah, are you terminally ill or not? And with no hope of recovery and cure of the ailment. And you also do not, you have lost your capacity of making decisions. Supposing you have brain hemorrhage, obviously you have lost your capacity to take decisions. That is where the living will come in. The treating physician is made aware of this document by your guardian or son or daughter or whosoever it is about the advance directive. He will then ascertain the directive genuineness of the same and authenticity with reference to existing digital health records of the patient, if any, and from the custodian of the document that I said earlier, that's municipal corporation. So it can check from there. It can also check for himself from your record. Now, what was given earlier was that the instructions in the document must be given due weight by the doctors. And it was only after they were satisfied that they had to give that they were done. But this is also taken care of now. The physician treating the patient is satisfied that the instructions given in the document, which is your living will, needs to be acted upon and shall inform the person or person named in the advance directive, as the case may be, about the nature of the illness, availability of the medical care, and consequences of alternative forms of treatment and consequences of remaining untreated. He must also ensure that he believes on the reasonable grounds that the person in question understands the information provided, has cogitated over the options, and has come to a firm view that the option of withdrawal or refusal of medical treatment is the best choice. So the doctor tells you these are the options. I can give this treatment, option treatment, third treatment, but the chances of recovery is nil. And then you take that call, informed decision by the guardian, your son or your wife or your husband, that it should be done. The hospital where you are admitted for medical treatment then constitutes a primary board of doctors. Two of them are experts. The treating physician also becomes part of that. Two experts come into it, which should at least have the specialty in the disease in which you are suffering for at least 5 years. So 5 years experience is the qualifying for those experts to be part of this committee. And who in turn then visit the patient, examine the patient, and then feel satisfied that they can do so, that yes, the person is suffering from this part. And once this is done in the presence of the person whom you have nominated, that means your wife, guardian, or anybody, and preferably within 48 hours of the case being referred to it. So now a timeline has been laid down. ये नहीं कि डॉक्टर साहब अपने टाइम से आएंगे. The board has to examine this issue within 48 hours. So timeline has been fixed. In that sense, then they certify that whether it should be carrying out the instructions or no, he's not in a state where they should carry out this instruction. Then decision is only on primary option. In the event primary medical board certifies that the instructions contained in the advance directive ought to be carried out. In that eventuality, a secondary medical board comprising of one registered medical practitioner nominated by Chief Medical Officer of the district and at least two subject experts with at least 5 years experience of the concerned specialty who were not part of the first one are made members of the second committee, second board. Then they examine it again. They visit the hospital where the patient is admitted and concur or not concur with the primary board. If they concur, then the matter will go forward. But if they don't concur, then the question of withdrawal of the medical aid does not come in at all. Then comes the question of, I have already said that to you, when the permission is refused by the medical boards, either primary or secondary, in that eventuality, it will be open to the person. Supposing I am the guardian and I find the board has gone wrong, board should have agreed, then my choice is to move the High Court, wherever that patient is, and ask the High Court to pass an order that the medical should be stopped, because this is the condition. So it is checks and balances are provided in the directive. So it's not that anything that you say would be acted upon without their being. So therefore, first the primary doctor attending you will certify, then primary board comes in, secondary board comes in. Then in case they are not in conformity with each other, you get a right, or not you, the guardian gets a right, or your son gets a right to move the High Court under a constitutional jurisdiction of Article 226 to ask the court to examine it. And if the court is satisfied, court will pass that order to say, stop this medical aid to, or all these gadgets to him. Let him have his life, his dignity to death. We won't do that. Now then, I must also add here for your consideration that it is not that the High Court on the judicial side sits down and passes the order. The High Court is within its power to constitute a committee. Again, because there's a difference of opinion between primary and secondary, or maybe both have refused, and the High Court will have free to constitute an independent committee, again consisting of 3 doctors, maybe cardiology, neurology, depends upon what kind of disease you have, and then come to the conclusion whether such a permission should be granted or not. So these directives are for the benefit of all of us. Their benefits are attached, and this has nothing to do with your will by which you will dispose of your assets. That means you have bank accounts, you have shares, you have properties. That will come operative post your death, while this will comes into operation while you're still alive, but only for the limited purpose कि आपको मेडिकल एड नहीं मिलनी चाहिए, मेडिकल चीजें मशीनें उतार दी जाए, आपसे ऑक्सीजन उतार दी जाए, वेंटिलेटर उतार दिया जाए, उसके लिए काम आएगी, so that actually you're living, but that living will is different from a will that you execute and operates after the death of somebody. So what I'm saying is this, that you may consider this. It is in the interest of each one of us that we execute this document and put it into the custody of the municipal corporation. Also give it to one of our, whosoever is our guardian or executor, whom we appoint, so that if the necessity comes, and I am not able to take that decision at that stage, I'm incapable of doing so, that person can take decision for me, and that decision will be subject to all these queries that are raised up. These are watched. You have these significant checks and balances. Once you go through that, then alone will the doctor be entitled to stop the medical facility to you. This is how we bring this living advanced medical directives, AMD, in India. We are now using them quite a bit. I find a lot of people are consulting that what should we do and how should we do. As Mr. Dr. Bobby called upon me to be with you, I'm grateful to him who have given me this opportunity. If there's anything that I can answer, I'll be very happy to.
Amar, Mr. Chandhiok ji, what a lovely disposition. एक ऐसा टॉपिक जो कि सबके माइंड में कंफ्यूजिंग रहता है. I think I'm sure I've already got so many questions. I'll just take 2-3 clarifications, Chandhiok sahab.
Please do.
Yes. Suppose there are 2 children of an individual, and I have made a will. One of them disagrees with my will, and one of them डॉक्टर को कहता है जी मेरे पिताजी की विल है, इसको एक्सिक्यूट करिए, और दूसरा कहता है नहीं जी ये तो उन्होंने जबरदस्ती बनाया. What happens in that stage?
That's what I'm saying. In that eventuality, the person who disagrees, speaking पहली बात तो इस willing will में आप एक को nominate करेंगे, दोनों को नहीं.
Okay.
जिसने nominate किया, he will start the process. But supposing your other brother or the person's other sister or somebody wants to object it, then he will have to rush to court to say this decision taken by me is wrong.
Right. So
no other choice.
चीज क्लैरिफाई होगी कि दूसरा कोई भी रिश्तेदार हॉस्पिटल के अंदर आके वहां पे कोई कुछ नहीं कह सकता.
नहीं कर सकता.
कोर्ट दिस इज
सकता. यस.
क्योंकि इसी डर से मेरे पास 2-3 एल्डर्स ने चंडियोक साहब जब डिस्कस किया, उनका जी मैंने अच्छा बिफोर आई गो फर्दर, सो आई कैन नॉमिनेट एनीबडी इन द वर्ल्ड. Anybody.
You nominate your brother, you can nominate your friend, you can nominate somebody other than my children.
Other than?
Yes. Nobody.
Nominate a friend. Can I nominate a doctor?
Yes, nominate a doctor. Supposing you have a personal physician who has been looking after you for ages, he is the best person, so you nominate him.
और ये बहुत लोगों ने मुझे पूछा कि मैं किसको नॉमिनेट कर सकता हूँ.
किसी को भी कर सकते हो.
किसी को भी कर सकते हैं. This is the most reassuring statement. क्योंकि जिसको मुझे पता है कि आने वाले दिनों में मेरी तबीयत खराब हो सकती है. So my doctor becomes the best nominated person to carry out that orders. Now, you just mentioned the board. Who appoints the primary board, sir?
The hospital where I am admitted.
So, देखिए, ये परिवार वाले नहीं कह सकते आप इनसे पूछिए. नो,
No, no, no.
एक लीगल प्रोसीजर है. आई एम ओनली आस्किंग दीज क्वेश्चंस फॉर क्लैरिफाइंग टू एवरीबडी कि आपने अगर ये बनाया, सबसे पहले तो वकील से डिस्कस करिए, वो आपको तरीका बताएंगे. लेकिन जो आज इसका लेने का पर्पस क्या था कि बहुत सारे हमारे एल्डर्स इसी कश्मकश में, जो जैसे बताया चंद्रोक साहब ने, 2-2 हफ्ते 3-3 हफ्ते वेंटिलेटर पे चलते ही जाते हैं, क्योंकि डॉक्टर कोई डिसीजन लेना नहीं चाहते, घर वाले कुछ करना नहीं चाहते. एंड क्या चंद्रोक साहब ने सबसे पहले लाइन दिया, ये मदद करता है डॉक्टर्स को भी एक सही तरीके से लाइफ को एंड करने का. सो इट इज नॉट ए मर्डर, it has helped the doctors to take valid decisions which are in the interest of the individual. So दोनों को मदद हुआ इससे. जो एल्डर्स हैं उनको अपनी लाइफ की डिग्निटी मेंटेन करने में, और डॉक्टर्स को अपनी एथिक्स और डिग्निटी में सर्विसेज डिलीवर करने में. So it has helped everybody and helped all society. Please, there is a word by club. I'm not finding your name. You can unmute yourself and ask me your question, please. The person who's raised the hand. Yes, please, go ahead. I did see. So anybody else who wants to? Yes, Goel sahab, please go ahead. Unmute कर लीजिए अपने आप को. Goel sahab, please unmute yourself. नहीं, अभी अनम्यूट नहीं हुए आप. Meanwhile, Chandhiok Bedi sir, if you want to go ahead with your question.
Chandhiok sir, really very, very.
My question is this.
एक मिनट गोयल साहब, मिस्टर बेदी साहब को कर ले फिर. यस बेदी साहब.
Really, I'm impressed with the systematic explanation of the whole subject by Chandhiok sir. My query is, he has pointed out a various number of boards, primary, secondary, court cases, and all that, which all involve expenses. Now, those expenses, every patient may not be able to bear it. Who bears those expenses? Number one. Number two, there may be a stage when the doctors say, yes, this is possible to treat the person, maybe taking abroad or any other financial expenses, but the patient or his family is not able to afford it. So therefore, they are in dilemma. In such cases, who take the decision and what happens?
No, this decision will still be taken by the board. We can't give decision to anybody else. Now the question is, who bears the expenditure? Now, two ways to go by it. One, that if the hospitals today have a CSR fund, they will have to cater to that. And they will use that fund to come to your help. The other could be there are certain NGOs which help people to come to your aid. You can apply to them and ask for their help. Because let's test your argument only. Now, if I am gone to a hospital and I am not able to afford it, somebody must be paying my bills. No hospital is going to treat me without it, especially if it is a private hospital. Government is separate. So in a private hospital, you will have to probably bear it. If you can't bear it, then obviously you go. But the answer is otherwise also. Supposing you are in a government hospital, you are in an institute, you are in Safdar, then the doctors can't ask you to pay for that panel. They will not to make any payment.
They will not pay. Bedi Sahib, have you got your answer?
I think he has explained it. That may be a little difficult situation, but one has to solve it. Thank you.
Right. Goel Sahib, please go ahead. Goel Sahib, unmute कर लीजिए. जी गोयल साहब. नहीं, अभी I can't hear you. Goel Sahib, I can't hear you.
My question is, if this is to be written by himself and he doesn't know the disease, he doesn't know the end, can one write a living will at this time in his good time? Or he has to write only when he is in the last one?
No.
You
He
can
can write today. It will be valid when he's at that stage.
No, but I don't know the name of the medicine. I don't know the name of the
You
disease.
have to know the name of the medicine. You have to say, if I am in a particular state,
take.
that's all, nothing more. मेडिसिन क्या है, आपको क्या बीमारी है, उसको छोड़ दीजिए. आपने लिखना है कि मेरी ये स्टेट अगर हो गई तो आप मेरे गार्डियन या मेरा लड़का या मेरी वाइफ, you will be the one who will take a decision that the hospital should start giving me anything more further.
Goel साहब क्वेश्चन इज फॉर एवरीबॉडी. वेरी नाइस गोयल साहब, आपने ये पॉइंट उठाया कि मैं कब लिखूं अपनी बिल को, लिविंग बिल को. चंडियोक साहब ने क्लैरिफाई किया, आज आप बिल्कुल हेल्दी हैं, आप योर 35 55 year old person, you write a will in the eventuality what Mr. Chandhiok is clarifying, but he's also clarified one more point. आप अपनी will को बदल सकते हैं. Suppose साल बाद आपको कैंसर डेवलप हो जाता है, then you can change your will. Isn't it? I can change my will.
Very similar to death will. Very similar to death will.
Ji. Any other questions by anybody else, please, before I
have a question, Dr. Grewal.
Yes, Subir, please go ahead.
My only question is, how long does this process take once it goes to the primary board, secondary board, and so on? When the decision finally comes
the directives provide it that in 48 hours the first board has to clear, one way or the other. So it will take maybe another 48 hours or maybe 60 hours, because when that report comes, then only you will take a decision to go to the next board. Auto constitution will take a day or so. So timeline of 48 hours is given for the primary board. So then comes the secondary board, which should also take 48 hours or maybe 70 hours or 50 hours. That's all.
It's not indefinite.
No, it's not indefinite.
There's a question. Any other, Subir?
Yeah, that's all I want to know. That's all.
Dr. Shravan Gupta, if you don't make a living will, who can take decision to terminate life supporting services? I think that's what was the whole question why this came in, Mr. Chandhiok.
Yes.
That's right. So, and Lekhraj Chukji, suppose a person has not executed any will and situation comes as discussed, then what he should do? Well, Lekhraj ji, yes, Chandhiok sir, please.
Yes, even then, obviously, it's not that if I am not left the will, nobody can do it. My children can do it, my wife can do it. It's not possible. But what is there is that you never expressed your desire.
That's important.
As important that. That's the only question.
That's the
decision is their decision. Here, decision is your own decision.
Your own decision.
You are mandating that if I reach that stage, please stop this medical facility to me. That's all.
That's GD Sharma ji, please go ahead.
मेरा सवाल ये था कि अगर कोई सैंपल इसका शेयर कर दिया जाए तो सबके लिए बहुत कन्वीनियंट होगा.
दोबारा बोलिए.
एक सैंपल आप नहीं ले तो बेटर है, क्योंकि आज हमारे
कोई फॉर्मेट इसका अगर शेयर कर दिया जाए तो सबके लिए बहुत.
नहीं, मैं इसलिए कह रहा हूँ शर्मा जी कि हर आदमी की अपने सर्कमस्टांसेस हैं, हर आदमी की अपनी स्टेट ऑफ माइंड है, किस वक्त वो चाहता है ये. तो अगर आप लिख देंगे तो फिर सब कॉपी हो जाएगा. और यही मैं कह रहा हूँ, एआई में तो जाना ही ना इसके लिए, क्योंकि एआई में तो गड़बड़ है सब कुछ इसके लिए. आप अपने बातों से लिखिए कि मैं इस स्टेट में पहुंचूं, when I think, when my doctor attending on me feels that it is not possible for me to recover, that's the time when you do it. That's all.
Sunanda ji is asking, can I write the living will while in hospital and I'm mentally sound?
Yes, you can.
You can.
As long as you're mentally sound, even if you're in the hospital, you can write it.
What is the role of witness?
The role of witness is to confirmation that you have executed this document. And the same role is by the notary or the officer. So you are only certifying that Mr. Chandhiok has executed his living will when he was sound deposing mind. He knew what he was writing. That's the purpose.
Manjula ji is asking how to write which stage. Manjula ji, question clear nahi hai. Would you like to ask it yourself, please? What is your question? आप ये पूछ रहे हैं कि मैं कब लिख सकती हूं, या आप पूछ रहे हैं कि मैं बीमारी या बीमारी से पहले लिख सकती हूं कि नहीं? यस मंजुला जी, प्लीज गो अहेड. यस मंजुला जी, आपने यू रेज योर हैंड. गोयल साहब बोलिए. अनम्यूट कर लीजिए प्लीज, गोयल साहब अनम्यूट कर लीजिए।
मेरा क्वेश्चन ये है सर कि डेथ विल में तो खाली 2 विटनेस की जरूरत होती है। इस केस में आपने एक नोटरी या गैजेट ऑफिसर को ऐड कर दिया।
हमने
डेथ
ऐड नहीं किया जी, पहले इसमें मैजिस्ट्रेट एडिड था, हमने मैजिस्ट्रेट को हटा के नोटरी कर दिया।
एग्री
मैंने आपको बताया नोटरी तो घर आ जाएगा, पैसे लेगा घर आ जाएगा।
नहीं, लेकिन डेथ विल जो होती है, गिफ्ट बाद में जो होती है हेयर्स को दिया जाता है, उसमें तो खाली 2 विटनेस की जरूरत है।
मैं अग्री करता
नॉर्मल
हूँ आपसे जी, ये लिविंग विल है, ये डिस्टिंक्शन बता रहा हूँ मैं आपको।
दोनों में फर्क है, वो आके
उसमें
बात खुलेगी।
उसमें भी आदमी थोड़ा अपनी उम्र से यंग होना चाहिए, एंड प्रेफरेबली इफ ए डॉक्टर, ये भी होना चाहिए डेथ विल में।
नहीं, ये कोई रिक्वायरमेंट नहीं है।
ऐसा नहीं है।
As long as you have a sound disposing mind,
That's
you can
it.
execute a will, whether it's living will or the will after your death. It
No,
makes no
not this,
difference.
Dr. Dantas. जी
हाँ,
मंजुला,
Small question.
जी मंजुला जी प्लीज गो अहेड। नहीं
I,
आप, यस प्लीज,
Asha Goyal, I have a question.
यस प्लीज गो अहेड मैम।
Somebody who goes, let's say, for an operation or something like that, a neuro operation or something like that, and just before going, can they, because it's not necessary that it has been done beforehand, at that time, can they write that if this happens to me, then that is the time the medical this thing should be terminated. And at
Yes,
that time, the whatever is a way to write the will, that time it can be written.
yes, it can be written. There is no problem about it.
इट इज आशा जी वेरी राइट कि मैं ऑपरेशन पे जा रही हूं, अगर ये कॉम्प्लिकेशन,
Yes.
यस
बिल्कुल लिख सकते हैं जी, बिल्कुल लिख सकते हैं 100%.
राइट,
Okay.
वेरी गुड क्वेश्चन।
Okay. Thank you.
डॉक्टर शाही बोलिए प्लीज, अनम्यूट योरसेल्फ मैम, मैम अनम्यूट योरसेल्फ।
सिर्फ मैं मिस्टर चंदोक से थोड़ा पूछना चाहती थी कि इन कंडीशन ऑफ एंथोइजिया वेयर यू आर सफरिंग chronic problem and the end result is not good, can they just apply for their termination without pain?
No, that's what I'm saying. Even
तो-
if you were to say in your living will that it should be terminated, your
They can-
decision will have to go to the doctor, then the first board and the second board.
यूथनेसिया
Only you are saying that I don't want to. So it's subject to check and balances, Naji.
डॉक्टर शाही, यूथनेसिया इन इंडिया इज नॉट अलाउड।
not allowed. Okay,
No.
fine, thank you.
Subir, any other question please?
I just wanted to know today if I make a living will, who is the first person that I should actually I want to make a living will?
Normally speaking,
first
you should
person
have
I should-
somebody related to you. But there's no bar you can make anybody. You can make your friend.
Whom do I my first point of contact when I want to make a
Your
will?
first point of contact would be the person whom you're naming. Your
Your
first point of contact would be your 2 witnesses.
Okay.
They will be with you, na?
But what about drafting the bill itself, the format?
What
How
I'm
will
saying,
I?
draft is nothing. It's कुछ में वो नहीं
Nothing,
है.
you just write it your way.
You write it
Okay.
your way.
Okay.
It
Right.
is it is not, it is a will which is your mind and your heart you're speaking out. There's no legality in it.
Yes,
Okay,
yes.
so then I get my 2 witnesses and
However,
then
you should be clear. In your intent, in your words, you should be very specific and clear. To
Right.
say, इस stage पर आने पर, please medical treatment बंद हो जाए.
Right. So Ranjit Singh ji, before we start ending, Ranjit Singh ji, anything you want to say please?
हाँ जी सर, तो मैं चंदोक सर को पूछना चाहना सर
जी
सर ਹੁਣ ਆਪਾਂ ਕਿਸੇ ਨਾਲ ਗਲਤੀ ਹੈਗੀ ਆ
ਹਾਂਜੀ
ਤੇ ਬਾਈ ਚਾਂਸ ਉਸ ਬੰਦੇ ਦੀ ਸਭ ਤੋਂ ਪਹਿਲਾਂ ਡੈਥ ਹੋ ਜਾਂਦੀ ਹੈਗੀ ਆ ਤੇ ਉਹਦੇ ਵੀ ਇਫੈਕਟ ਹੋਏਗਾ।
नहीं मैं सवाल नहीं समझ सकिया जी.
दोबारा बोलो।
हेलो,
हाँ दोबारा बोलो रंजीत
भी
सिंह।
जैसे मैंने किसी अपने दोस्त, हाँ जी, मैंने अपने किसी दोस्त के नाम पे विल कर दी या अपने फैमिली मेंबर के नाम पे विल कर दी किसी की, तो बाई चांस उसकी डेथ मेरी डेथ से पहले हो जाती है
अभी मैंने
तो
आपसे
फिर
पहले
उसका क्या
कहा कि
होएगा?
आप कह सकते हैं, आप नॉर्मली क्या करते हैं विल में, देखिए आप कहते हैं मैंने अपने एसेट्स सारे विल कर दिए, बिक्विथ कर दिए अपनी बीवी को. सपोजिंग मेरी बीवी प्री डिसीज कर जाए मुझको, तो मेरे दोनों बच्चों को
हाँ।
पता चली जाएगी
ऑटोमेटिक में चली जाएगी.
Similarly, you will say here also कि अगर वो मेरे को predecease कर गए तो Mr. So and so will be the next person to
You
come.
will nominate a second person in the will itself.
Thank you, sir. Thank you, sir.
So I think before we close, Mr. Marwaji, your closing comments. Usually Mr. Marwaji closes our discussion. Marwaji, can you hear me? Please, I can't hear you. जी हाँ जी बोलिए सर.
जी सर थैंक यू वेरी मच. मैं सबसे पहले सत श्री अकाल करांगा चंडोक साहब ਨੂੰ. चंडोक साहब एक बड़ी पोजीशन आई हुई ਸੀਗੀ ਦਾਦੇ ਨਾਂ ਤੇ ਪ੍ਰਾਪਰਟੀ ਹੈਗੀ ਹੈ ਤੇ ਉਹ ਫਾਦਰ ਬਿਲ ਕਰ ਸਕਦਾ ਹੈ.
इस सवाल का जवाब आराम ਨਾਲ बोलो.
ਦਾਦੇ ਦੇ ਨਾਮ ਪ੍ਰਾਪਰਟੀ ਹੈਗੀ ਹੈ.
ਕਿਹਦੇ ਨਾਮ ਤੇ ਪ੍ਰਾਪਰਟੀ ਹੈ
ਸਰ? ਦਾਦੇ ਦੇ ਨਾਮ ਪ੍ਰਾਪਰਟੀ ਹੈਗੀ ਹੈ.
ਦਾਦੇ ਦੇ ਨਾਮ ਤੇ?
ਹਾਂਜੀ ਦਾਦੇ ਦੇ ਨਾਮ ਤੇ ਪ੍ਰਾਪਰਟੀ ਹੈ ਤੇ ਪਿਓ ਵਿਲ ਕਰ ਸਕਦਾ ਹੈਗਾ ਬੱਚਿਆਂ ਦੇ ਨਾਲ ਬਿਲ ਕਰ ਸਕਦਾ ਹੈਗਾ.
ਕਿਉਂ ਨਹੀਂ? ਦਾਦਾ ਵੀ ਨਹੀਂ ਕਰ ਸਕਦਾ? ਦਾਦਾ ਵੀ ਕਰ ਸਕਦਾ, ਬੱਚਾ ਵੀ ਕਰ.
ਤੇ ਦਾਦਾ ਨਹੀਂ ਹੈ, ਦਾਦਾ
सॉरी
मेरी आवाज नहीं आ रही.
सर मेरे को आवाज थोड़ी नहीं आ रही बिल्कुल सही तरह. सर दादा चला गया है, दादे ਦੇ ਨਾਂ ਦੀ प्रॉपर्टी हैगी है.
मैं कह जी
प्रॉपर्टी इन द नेम ऑफ ग्रैंडफादर. सर
अगर ग्रैंडफादर की विल ਜਿਹੜੀ है अगर नहीं है तो ग्रैंडफादर के जितने बच्चे उन्हें सारे ਨੂੰ बराबर मिलेगी.
Only son is there, sir. Only son.
Marwaji, this is something different from that. VR from USA is asking if a person has made his will in UK, moved to USA, his property in UK and you say in question, will that will be okay?
It says will has no jurisdiction question.
No jurisdiction.
You can will your property from London and sitting in India. No problem.
So I think, first of all, may I request all of you to please join me in giving a big hand to Chandhiok sir for sparing his time.
Thank you so much.
Thank you for this opportunity of coming, leaving the courts. I think he is one of the busiest lawyers in the country. Despite that, his passion for all of us. Yes, Ashwini? Okay.